This story is a work of fiction. Teresa Vaugh held two printouts side by side under the fluorescent light of the Riverside Municipal Vehicle Facility. The first was an intake sheet. Filled out the night a silver sedan arrived on a flatbed. No blue paint transfer, it read, in her own handwriting. The second was an evidence update, added less than a day later. Blue paint transfer recovered from front bumper, it read, in someone else's. She checked the access log between the two entries. One name appeared, one badge number, one officer, Calvin Strickland. On the access form beside his signature, two boxes were checked. Nothing removed, nothing placed. The impound cam's timestamp sat directly between the clean intake sheet and the paint that hadn't existed the day before. Before sunrise, Strickland had created two official versions of the same sedan. Only one of them contained blue paint. To understand how that happened, it helps to go back 11 hours to 11:14 at night, when an undamaged silver hybrid sedan pulled out of the parking garage beneath the Asheford County District Attorney's Office. Assistant District Attorney Imani Rhodes had spent the evening preparing for a closed review scheduled for the next morning, 7 vehicle cases out of the 9th District. Files that didn't sit right the longer she read them. Damage descriptions that changed after a vehicle reached impound. Paint transfer evidence that surfaced weeks late. In follow-up photographs rather than the original intake report. Supplemental reports written in language vague enough that it was never quite clear which officer had actually seen what he claimed to have seen, or whether he'd simply been told about it afterward and folded it into his own account as if he had. Officer Calvin Strickland's name kept appearing, sometimes as the arresting officer, sometimes only as the one who'd walked a vehicle through impound intake, always somewhere close to the point where a case file's story started to bend. The review itself was supposed to stay confidential until morning, but a records request Imani had filed that afternoon, pulling his old case files for comparison, had already passed through a clerk's desk 2 doors down from where Strickland worked. It wasn't a leak. It was simply a records system that hadn't been built with this kind of review in mind. And Strickland had noticed his own name flagged on a pull list before the day was over. Imani had built a small stack of sticky notes on 3 of the files by the time she finally closed her laptop, each one marking a place where a report described something as observed that read, on a second pass, more like something assumed. She wore a pair of smart glasses that looked like any other pair, the kind she'd used all evening to record short voice notes to herself about the files, while her hands stayed free for turning pages. They'd already begun uploading, quietly and automatically, before she ever left the building, backing up everything she'd recorded to a server none of the officers in those files would ever think to check. The garage camera recorded her sedan pulling out at 11:14, a smooth hood, an intact side mirror, an unbroken windshield. Less than 10 minutes later, dispatch put out a hit-and-run description. A blue sport utility vehicle traveling westbound, possibly carrying front-end collision damage. Imani was driving a silver sedan, eastbound, with no damage of any kind. Officer Calvin Strickland and probationary officer Lucas Avery picked up her car anyway, easing into the lane 2 vehicles behind her at a red light. "That's not our vehicle," Avery said, reading the description off the screen mounted between them. "Wrong color, wrong body type, wrong direction. She's going the opposite way from where dispatch put the collision." Strickland didn't answer him. He didn't run the plate either. He just kept pace. Close enough that Imani noticed the headlights holding steady behind her for 3 blocks longer than made sense. For 2 cars, simply headed the same way. She checked her mirror once, then again, and when the lights finally came on behind her, she didn't panic and she didn't accelerate. She signaled, found a wide, empty stretch of curb beneath a street lamp outside a closed pharmacy, and pulled in slowly, giving him every extra second he might need to see exactly what he was approaching. She put both hands on the wheel where they'd be visible through the windshield, and waited. "What's the reason for the stop?" she asked, once Strickland reached her window. He didn't answer that either. He walked to the front of her car instead. Strickland's body camera sat dark on his chest, the small light that should have blinked amber, showing nothing at all, a detail nobody would notice until much later, when the department's own activation logs showed his camera had never been switched on that night, and Avery's had been pointed at the ground for most of the stop, angled down toward his own boots rather than at the car. He raised his baton. The first strike landed on the hood, leaving a dent. The second broke the housing on her side mirror. The third put a crack across her windshield. Imani's glasses recorded all 3 impacts, along with something Strickland hadn't thought about: the pharmacy window behind him, throwing back a clean reflection of her sedan in the seconds before he ever swung the baton, smooth hood, intact mirror, unbroken glass. "Officer, why are you damaging my vehicle?" she asked. He came back to her window. "You're being detained in connection with a hit and run. The fresh damage on this vehicle is consistent with the allegation." "You created that damage," Imani said. "That's your account," Strickland said. "Mine goes in the report." Imani looked past him toward Avery, standing a few feet back. "You saw this car before he touched it," she said. "Tell him what you saw." Avery knew exactly what he'd seen. He said nothing at all. Strickland ordered her out of the vehicle. She complied, announcing each movement before she made it, keeping her hands where he could see them the entire time. He handcuffed her, then leaned in close enough that only she would hear it. "You should have left 9th District files alone," he said. The glasses caught that too. It wasn't a mistaken identification. He knew exactly who she was and exactly what she'd been reading. He photographed the damage he'd just created and began building his account before anyone could look at hers. Damage visible during initial approach. Driver immediately denied involvement. Driver attempted to influence the assisting officer's recollection. Avery watched him write it. He didn't correct a single word. Strickland radioed that a female driver was in custody and that the vehicle damage matched the reported hit and run. The dispatch screen the whole time still read blue SUV westbound. At the 9th District station, booking adopted Strickland's language without question, the intake form filling in exactly the way his radio call had already described it before Imani ever reached the building. Imani asked for counsel and refused to sign anything beyond the property receipt, reading each line of it twice before initialing. The same habit she'd have used on any client's paperwork if their positions had been reversed. Her glasses went into a sealed evidence pouch before dawn. While Strickland finished an arrest report claiming the damage had existed before he ever reached her window. That she'd been nervous and argumentative. That she'd tried to influence the officer standing beside him. He signed it. Avery wrote his own supplemental report in careful, narrow language. He stated that he'd observed vehicle damage during the detention, technically true, and carefully silent about whether that damage had existed before the stop, and silent about who he'd watched create it. The kind of sentence a lawyer could defend in a hearing, and a conscience would have a much harder time defending anywhere else. By morning, Imani was sitting across from Arthur Gaines, an independent attorney the district attorney's office had brought in to keep the case away from anyone with a stake in it. The office placed her on administrative leave under standard procedure, since she'd been arrested in a matter connected to her own official review. Her system access was suspended within the hour. She was told not to contact any witness, not to discuss the case publicly, the same neutral language the office would have used for any prosecutor caught up in any unrelated arrest, written by people who had no idea what that language was quietly accomplishing for Calvin Strickland. Nobody in that decision meant to help him, but removing Imani from the 9th District Review was exactly what he needed, and the department had just done it for him without knowing why, 3 weeks before her closed review of his files was ever supposed to happen. "Don't reach out to Avery," Arthur told her. "Not a message, not a call, nothing that could look like influence later. No matter how badly you want to know what he's thinking right now. I'll request that every file you accessed gets locked, and that the audit history is preserved exactly as it stands right now, before anyone has a reason to touch it." Imani understood the logic, even as it cost her something to accept it. She was the victim in this case, and the original reviewer in the other one, and those two facts couldn't be allowed to blur into each other, not if anything that came out of either case was going to hold up later. "I'm the one this happened to," she said. "I'm not going to be the one who investigates it." Arthur nodded, like a man relieved not to have to argue the point. Before the glasses left the property room, Arthur flagged the device as containing potential attorney work product, since hours of Imani's own case notes sat on the same drive as the footage of her arrest. A filter team reviewed the file index first, separating anything touching her 9th District analysis from the narrow window of footage that actually mattered to the hit-and-run allegation, so that Celeste would only ever receive the segment relevant to the stop itself, sealed apart from the rest. The glasses went to forensic examiner Celeste Park. She photographed the sealed pouch before opening it, tamper strip intact, and logged the serial number against the property receipt Imani had signed at booking, confirming the two matched before she touched anything further. She broke the seal under a fixed evidence camera, narrating each step for the record, and created a forensic image of the device before playing a single original file, so that nothing she reviewed afterward could touch the source. From there, 3 things mattered: device authenticity, the serial number, the intact seal, the registration matching Imani's own pair; file integrity, upload timestamps against the arrest report's stated time of stop, the internal clock, no gaps or compression artifacts suggesting a frame had been added or removed, and location, GPS data plotted against the collision site dispatch had described. The 2 routes never coming within a mile of each other. None of it showed what Strickland needed it to show, and all of it showed what Imani already knew. The uploads had begun before the traffic stop, not after. The garage footage showed an intact sedan at 11:14. The pharmacy reflection showed the same intact sedan seconds before the first strike. The recording captured all 3 impacts: Imani's accusation and Strickland's own voice telling her she should have left 9th District files alone. "I'm not calling this flawless," Celeste said, when Arthur asked her to characterize it in terms a judge could rely on. "I'm telling you what the data supports. Nothing more than that, and nothing less." The original device is consistent with the pair registered to Imani Rhodes. The upload times predate the arrest report by several minutes, which means whatever's in that file existed before Officer Strickland ever picked up a pen. There's no editing indicator anywhere in the file, at any timestamp, on any pass. The GPS doesn't place her anywhere near that collision, not within a mile of it. Arthur didn't send the recording to the press, and he didn't send it to anyone inside 9th District. Not even the deputy chief, who'd called twice asking for an update. He gave an authentication summary to the outside prosecutor assigned to the preliminary hearing, and nowhere else. because the surest way to lose a case built on careful evidence was to let it start looking like a performance before anyone under oath had a chance to answer for it. A preservation notice reached Riverside Municipal Vehicle Facility the same week. It didn't bar police from the vehicle entirely. It required anyone entering the bay to log their name, badge number, reason for access, time in, time out, and anything removed or placed on or inside the car. Teresa Vaugh attached the notice to Imani's intake record. Her original sheet, written the night the sedan arrived, already said what it said: no blue paint transfer visible. That created a problem for Strickland. The hit-and-run he'd invented involved a collision serious enough to leave paint transfer somewhere on the responsible vehicle. His baton had left a dent, a broken mirror, a cracked windshield, but no paint. Because there'd never been a collision to leave any, so he found some. He pulled a small blue paint flake from an unrelated case file sitting in a records box 2 aisles over, a legacy evidence box from a closed case years old. The kind that had never been migrated into the barcoded system the department used for anything active, and so had no log tracking who opened it or when. There was no collection number on the flake itself, nothing that tied it to anything he'd ever need to explain, because nobody had ever expected it to leave that box again. He worked it loose with a thumbnail, folded it into a scrap of paper, and put it in his jacket pocket before he ever left the building. He told the desk sergeant he was headed to Riverside to check something on an open case, which wasn't technically a lie, and drove there alone. Teresa reminded him, at the door, that anything he removed or placed had to be logged, same as she reminded every officer who came through that entrance, whether they had a preservation notice attached to their vehicle or not. He nodded like a man who'd heard the reminder 100 times and stopped listening to it somewhere around the 20th. The impound camera recorded him, photographing the hood, the mirror, the windshield, working his way around the car the way an officer documenting damage might reasonably be expected to. Crouching near the front bumper, his right hand moving into his jacket, out of frame for less than 2 seconds, his closed hand returning to a narrow seam near the grille. 2 fingers pressing into that seam for a moment, before he stood back up and continued photographing, as if nothing about the last several seconds had been any different from the ones before it. The camera never resolved the flake itself. It was too small, too quick a motion, the angle too high to catch anything finer than a hand moving where a hand had no obvious reason to be. But it recorded the sequence, start to finish, without a gap, and a sequence without a gap was, as it turned out, more than enough. "Did you remove anything from the vehicle?" Teresa asked when he was done. "No," he said. "Did you place anything on or inside it?" "No." She marked both answers on the form exactly as he gave them. 41 minutes later, blue paint appeared in the evidence file, logged as transfer material discovered during a follow-up inspection. Strickland sent Avery another supplemental report to sign, worded carefully enough that it never claimed Avery had been present at the impound lot, only that he'd been advised of additional evidence and continued to confirm the original vehicle damage. "Why does this need my signature?" Avery asked. "Consistency matters," Strickland said. Avery signed it. Later that week, a message came through from Strickland's number. "Stay consistent. Your evaluation depends on it." Avery didn't delete it. For the first time since any of this had started, he made a copy and sent it somewhere outside the 9th District chain of command entirely. The preliminary hearing came 3 weeks later, in Courtroom 4B, Judge Marlene Hightower presiding, no press in the gallery, no crowd in the hallway, just the people whose choices that night had put them in these seats. "Establish the facts," she told the prosecutor, "not speeches." Strickland testified first, since his account had formed the original basis for the arrest. "What color vehicle did dispatch describe?" Arthur asked him. "Blue," Strickland said. "What direction?" "Westbound." "And Ms. Rhodes's vehicle?" "Silver, eastbound." "What connected those two vehicles before you initiated the stop?" Strickland didn't have an answer that survived the question. He said something about instinct, about years of experience recognizing a vehicle that didn't add up, and Arthur let him finish before moving on without commenting on it at all. "When did you first observe damage to her vehicle?" "Before I reached the window." "Did you strike the hood with your baton?" "No." "Did you break the driver's side mirror?" "No." "Did you crack the windshield?" "No." "Did you place blue paint on the front bumper during your visit to Riverside?" "No." Judge Hightower looked up from her notes. "Officer, you understand you're answering under oath?" "Yes, Your Honor. I'll ask you to keep that firmly in mind for the remainder of this hearing." Arthur called Celeste Park next. She authenticated the device, the seal, the serial number, the forensic image, and played the footage in order. The garage at 1114, the sedan intact. The pharmacy window. The sedan intact seconds before Strickland entered the frame with the baton raised. The first strike on the hood, the second on the mirror, the third on the windshield. Imani's voice, steady, telling him he'd created the damage himself. Then the last few seconds, low and close to the microphone. "You should have left 9th District files alone." Arthur let it end there and stopped the recording. He didn't need to say anything after it. He called Teresa Vaugh next, and she walked the court through the intake sheet, the preservation notice, the access log, Strickland's own signed answers, and the impound bay footage, the hand into the jacket, the fingers pressed into the seam near the grill. The paint that appeared in the file 41 minutes after he left. No single frame showed the flake itself changing hands. It didn't need to. The intake sheet, the access log, his own denial, and the timing of what appeared afterward told the same story from 4 different directions at once. Finally, Arthur called Lucas Avery. He sat straighter than the other witnesses had, the posture of a man who'd spent 3 weeks rehearsing what honesty might actually cost him and deciding to pay it anyway. He admitted the dispatch description never matched Imani's car. He admitted he'd watched Strickland strike it, all 3 impacts, close enough to hear the sound each one made. He admitted signing 2 supplemental reports that he knew were misleading, and a 3rd document he'd refused to sign at all. "Why sign the first 2 if you knew they weren't accurate?" Arthur asked. "I was afraid," Avery said. "My evaluation went through him. Everything about whether I keep this job for the next year at least ran through his signature before it ever reached anyone above him. Did that prevent you from writing what you actually saw?" "No," Avery said. "It made me afraid to write it. That's different, and I know it's different. And I've had 3 weeks to sit with exactly how different it is." He authenticated the message about staying consistent, reading it aloud when Arthur asked him to, and told the court he'd preserved it and sent a copy outside the department the same day he'd received it. He explained that he'd refused to sign a 3rd statement, one claiming the evidence chain had remained secure the whole time, because by then he'd already understood what signing it would mean, and what kind of officer he'd be agreeing to become if he kept going along with it. Judge Hightower dismissed the hit-and-run allegation for lack of probable cause. She ordered every report, draft, device file, dispatch record, impound record, message, photograph, and access log preserved in its current form. No exceptions, no discretion left to any department to decide what mattered enough to keep. She referred the full transcript to an independent prosecutor to evaluate false reporting, evidence fabrication, evidence tampering, witness intimidation, retaliation, and perjury. reading each charge into the record slowly enough that nobody in the courtroom could mistake it for a formality. She didn't convict him from the bench. That wasn't her role that day, and the story didn't need her to pretend it was. Before Strickland left the courthouse, a department integrity commander was already waiting near the exit and collected his duty weapon, his badge, and his access card without a word of explanation needed on either side. His patrol login, his evidence credentials, and his impound authorization were disabled before he'd even reached the parking lot. A call placed from a hallway phone the moment the judge's ruling was read. When he tried his employee card at the secured exit on his way out of the building, nothing happened, the light staying red no matter how many times he swiped it. A court officer had to open the door from the other side. Nobody applauded. Nobody needed to. An independent warrant review followed within the week, and Strickland was booked that same day, processed through the same intake procedures he'd built his career enforcing on other people. The criminal case and the department's administrative case moved on separate tracks from there, one answering to a judge, the other to a review board, with no interest in what either outcome meant for the other. The administrative findings came back, sustained for discriminatory retaliation, evidence fabrication, false reporting, improper use of force, and interference with a witness. Strickland was terminated for cause. His certification referred to the State Standards Board. The finding permanently attached to his employment record in a way no future resignation or retirement filing could quietly replace. Any department in the state running a background check would find it there, plainly worded, for as long as the record existed. The criminal case took longer. A grand jury indicted him on counts of evidence tampering, fabricating physical evidence, filing a false official report, perjury, and retaliation against a public official. He went to trial rather than plead, and a jury convicted him on every count but one, acquitting only on a narrower perjury specification tied to a single answer the prosecution hadn't fully nailed down. He was sentenced to 11 years, the judge citing the number of separate, deliberate acts involved, not one bad decision in the heat of a stop, but a sequence built and maintained over hours. The State Standards Board permanently revoked his certification the same month, closing off any path back into law enforcement in this state or any other that checked the registry. Avery received an unpaid suspension, sustained findings for false reporting and failure to intervene, loss of his independent patrol status, and permanent ineligibility to serve as a field training officer. Every report he'd signed without direct personal observation went back for secondary review, one file at a time, each one checked against whatever else existed to confirm or contradict it. His cooperation weighed in his favor when the board set his discipline. It didn't erase what his signature had already done to 2 supplemental reports before he'd found the nerve to stop. The district attorney's office reinstated Imani, withdrawing the administrative leave notice and replacing it with a conflict review memorandum, explaining plainly that her arrest had been connected to her own official examination of 9th District conduct, not to any wrongdoing on her part. The public docket was corrected, line by line. The phrase suggesting her vehicle damage was consistent with a hit and run was removed entirely, replaced with 2 short facts that finally matched what the evidence had actually shown. Charge dismissed. Evidence referred for officer misconduct investigation. Imani didn't prosecute Strickland herself. She couldn't, and she didn't try to, understanding better than most people in that building exactly why the line had to hold. An independent team took over the 9th District review she'd started weeks earlier, working from the same 7 files that had gotten her pulled over in the first place. files that now carried an eighth case nobody had expected when the review first began. One of those files belonged to Darnell Webb, a commercial driver whose case had involved its own late paint transfer evidence, tied to an earlier allegation from Strickland, involving a delivery van and a parked car nobody had ever produced a clear photograph of at the time of the original report. The chain of custody on that paint had never held up to scrutiny. No collection number, no technician's signature, no explanation for why it had appeared in the file 2 weeks after the vehicle had already been released back to its owner. But Darnell had accepted a plea years before, rather than risk a harsher outcome by fighting an officer's sworn report, with nothing but his own word standing against it. The plea cost him his commercial license within the month, months of lost wages, while he searched for work that didn't require driving, towing, and storage fees on a truck he could no longer legally operate, and a record that followed him into every job application since. The kind of line on a background check that never needed an explanation attached to it to do its damage. "I knew what I saw and what I didn't do," Darnell said, when the review team finally called him. "I just also knew what happens to a man like me if I stood in a courtroom and it came down to my word against his badge." The Independent Conviction Review Unit reopened his case, working from the same pattern that had unraveled Strickland's account of Imani's stop. The unexplained gap between intake and evidence, the missing technician, the timeline that only ever seemed to produce what the officer needed exactly when he needed it. The independent prosecutor joined Darnell's motion rather than opposing it, telling the court plainly that the evidence chain underlying the original plea could no longer be trusted, and the judge vacated the plea on that basis, rather than reopening the underlying facts from scratch. His driving disqualification was lifted. A compensation hearing was scheduled, though nobody pretended a hearing could hand him back the years already spent working jobs that paid a fraction of what his license once had. Darnell hadn't had smart glasses recording his encounter, or a prosecutor's understanding of how an evidence chain was supposed to work. What had happened to Imani in a pharmacy parking lot had likely happened to men like him for years, quietly, without anyone positioned to catch it, until one night it happened to someone whose glasses were already uploading before the first baton strike ever landed. Asheford adopted what the department began calling a vehicle evidence separation order. An arresting officer could no longer access an impounded vehicle alone. Any access now required an independent evidence technician or a second authorized employee present, continuous recording, and a logged purpose stated in advance. A rule built with enough room for a genuine emergency, without leaving room for exactly what Strickland had done. Any evidence discovered after intake now required a new barcode, a technician with no connection to the case, a continuous access log, and a written explanation for why it hadn't appeared on the original condition sheet in the first place. Every legacy evidence box still sitting outside the barcoded system was flagged for migration, each one logged, sealed, and given the same access trail a live case file already carried, closing off exactly the kind of untracked source Strickland had reached into without anyone noticing. Supplemental reports had to identify the source of every material statement, personal observation, radio information, or something learned later from another officer, each labeled plainly as what it actually was, so that a report could no longer blur the line between what a man had seen with his own eyes and what he'd simply been told to say he'd seen. A preservation notice now automatically extended camera retention the moment it was filed, locked report drafts in place before anyone could quietly revise them, and sent access alerts outside the arresting officer's own chain of command, so no single supervisor could manage what got seen and what didn't. Older 9th District vehicle cases were screened for the same signs: late evidence, changed damage descriptions, unsupported supplemental reports. Single officer impound access appearing again and again under the same handful of names. Not every case would be overturned. Nobody on the review team promised that, and nobody pretended it would be simple. But every one of them would finally be looked at by someone who hadn't already decided, before opening the file, what they expected to find inside it. Several weeks later, Imani left the office after an ordinary day, the kind with nothing in it worth writing down. Her sedan waited in the garage, repaired now, the hood smooth again, a new windshield in place, the mirror replaced, and sitting flush against the door exactly where it belonged. At the next light, she adjusted that mirror once, out of habit more than need, and caught her own reflection for a moment before it settled. It showed her the empty lane behind her, clear and undistorted. The light changed, and she drove on, past the pharmacy she hadn't gone back to since that night, past the garage entrance where a camera had once caught the last clean image of her car before anyone thought to damage it, on toward whatever the next case on her desk would turn out to need from her. Strickland had believed the first report would become the truth, simply because he wore the badge and wrote it first. The evidence proved otherwise. Chronology was never the same thing as credibility, and an official record was only ever as honest as the people willing to preserve what came before it. Should a probationary officer face real discipline for signing a report he knows is misleading, even if fear of his own evaluation is the reason he signed it? And should any arresting officer ever be allowed to enter a preserved impounded vehicle alone? Let us know what you think in the comments.